Please be seated. Paibososwa.
Thank you very much, and welcome back, everyone. So now we will take the submissions from the Council of the League of Arab States.
Mr. President, members of the Appeals Chamber, thank you for the invitation to this hearing on this important case. It is my honor to present to you the views of the League of Arab States with regard to questions posed in Group A. As the Appeals Chamber is aware, the League submitted observations on 16 July 2018, and it wishes to confirm to you today those observations and to extend on them, bearing in mind the questions that have been asked by the Appeals Chamber. At the outset, the League of Arab States wishes to reaffirm the importance that it attaches to the issues raised in Jordan's appeal. As was indicated in our observations, the League considers that the fight against impunity is of the highest importance, and that those responsible for heinous crimes must be brought to justice. This goal, however, cannot be achieved at any cost. The fight against impunity must take place within the framework of international law, including the rules that aim to guarantee orderly relations between states. The League wishes to call to your attention certain facts relevant to these proceedings. First, the League of Arab States was founded in Cairo in 1945 with the adoption of the Pact of the League of Arab States. Second, although the League began with 6 member states, today it consists of 22 member states and 5 observer states, which straddle the continents of Africa and Asia. Both Jordan and Sudan are member states of the League. Jordan became a member state on 22 March 1945, and Sudan on 19 January 1956, immediately after its independence. Third, throughout its history, the League has served as an important forum for its member states and observer states to coordinate their policy positions, but also to deliberate on matters of common concern and to settle Arab disputes so as to limit conflicts, including armed conflicts. Thus, one of the key purposes of the League is to help maintain international peace and security through dialogue among its member states. By way of example, the League was very active in addressing the Iraqi invasion and occupation of Kuwait in 1990-1991, including the atrocities that were committed in the course of that conflict. More recently, the League was very active in addressing conflict that arose in Libya in 2011. The League is also quite involved in addressing conflicts between its members and others. For example, at the Beirut Summit in 2002, the League adopted the Arab Peace Initiative, which is a peace plan for the Arab-Israeli conflict that has been supported by the United Nations Security Council and by key states and partners involved in the peace process. Fourth, the dialogue among member states of the League happens in large part through the holding of intergovernmental meetings and conferences. The League has an extensive range of meetings at the expert, organ, and ministerial levels, which then report for action at the annual summit of the League. The summit gathers together the heads of state and government of all members of the League to approve important decisions based on earlier meetings and to make plans for the upcoming year for the League, including in its relations to the United Nations. To date, the League has held 35 summits. Fifth, the representatives attending League summits are protected by immunities that arise under three sources of law. One source of law is the Pact of the League of Arab States, which provides in Article 14 that members of the Council of the League shall enjoy in the exercise of their duties diplomatic privileges and immunities. Another source of law is the 1953 Convention on the Privileges and Immunities of the Arab League, which provides the representatives of member states to conferences convened by the League shall, while exercising their functions and during the journey to and from the place of meetings, enjoy certain privileges and immunities, including immunity from personal arrest or detention. Both Jordan and Sudan are parties to the 1953 Convention. Jordan deposited its instrument of accession on the 12th of December 1953, while Sudan did so on the 30th of October 1977. I will return in greater detail to these sources of law later in my submission. The third source of law with respect to immunity is customary international law. In the League's view, customary international law accords immunity to a head of state from foreign criminal jurisdiction, with no exceptions whatsoever. Sixth, the overall purpose of the treaty-based immunities is to facilitate the exercise of functions of the League of Arab States in the territories of member states. Simply put, representatives of the League's member states must be able to travel freely to the territory of the host state without fear of arrest and prosecution. Indeed, as indicated in the 1953 Convention, the purpose is according privileges and immunities under Chapter 6 and Chapter 4 of that Convention to representatives of member states is to safeguard the independent exercise of their functions in connection with the League. The immunity of heads of state under customary international law is essential to safeguard friendly relations and intercourse between sovereign states. Seventh, of the 22 member states of the League, 5 are also parties to the Rome Statute. When those 5 states became parties to the Rome Statute, they knew of the existence of their obligations with respect to immunities that are owed to other League member states. And they knew that some League member states might not join the Rome Statute immediately. Article 98 of the Rome Statute provided the basis for reconciling any possible conflict between League obligations relating to immunities and obligations owed under the Rome Statute. Mr. President, I turn now to legal issues specific to Group A.
Before you do, Counsel, do I understand the submission so far to be to this effect? To the extent that there are immunity provisions for heads of state traveling to Arab League meetings, that immunity needs to be respected for purposes of enabling the Arab League achieve its purposes. If that is the understanding, would it then be something of a special argument that does not mean immunity generally under a customary international law, but immunity for purposes of enabling an international organization to fulfill its functions?
The respect for immunity in the literature of the League of Arab States is not limiting the supplying this immunity only for the purposes of the meeting of the League of Arab States. It's a general provision that does not delve into any specificities with regard to this particular issue. Mr. President, I turn now to legal issues specific to Group A. It is the League's position that pre-trial Chamber 2's decision of December 2017 and its interpretation of the obligations of states parties to the Rome Statute as regards to immunities of heads of state under international law is fundamentally flawed and will have serious negative consequences for the proper functioning of the Arab League, including on the holding of its summit meetings. It also sets obligations of a member state under the League's legal instruments in direct conflict with obligations under the Rome Statute where such a member is a party to the statute. As a general matter, the League has reviewed and fully agrees with the arguments set out in Jordan's appeal brief and is of the opinion that pre-trial Chamber 2's decision should be set aside in its entirety. My comments today are intended to address further some issues which the League finds particularly relevant at this stage of the proceedings. One of the questions of direct concern to the League is the present case in whether Jordan had an obligation to respect the immunity of President al-Bashir under the 1945 Pact of the League and under the 1953 Convention when he visited Jordan on 29 March 2017 in order to attend the 28th Arab League Summit. Both treaties were in force as between Jordan and Sudan at the time of the visit of President al-Bashir to Jordan. Pre-trial Chamber 2 addressed the question of treaty-based immunity only with respect to the 1953 Convention, and its reasoning was brief. The League considers that pre-trial Chamber 2 erred with respect to matters of fact and law. The following arguments are made by the League in its capacity as the depository of the 1953 Convention and an institution often called upon to interpret and apply both treaties. With respect to the pre-trial Chamber's error of fact, the League explained in its written observations that the Chamber was unable to conclude that Sudan was a party to the 1953 Convention because of a faulty translation by the Registry of the Court, which did not include Sudan among the member states of the League that had deposited instruments of accession. This was indeed later acknowledged by the Chamber in its decision granting Jordan leave to appeal. But this does not change the fact that the Chamber had at its disposal all the material to come to the right conclusion. And in the League's view, Jordan should not have been prejudiced by the error for which it bore no responsibility. The Chamber's failure to determine that Sudan was a party to the 1953 Convention constituted a serious error of fact. With respect to the pre-trial Chamber's error of law, the League respectfully submits that the Chamber erred in not acknowledging that while President al-Bashir was on Jordan territory for the League's summit, Jordan had an obligation to fully respect his immunities under both the Pact of the League of Arab States and the 1953 Convention, as well as under customary international law. The Pact of the League of Arab States creates certain organs for the exercise of the League's functions. Article 3 provides that the League shall have a council composed of the representatives of the member states. Each state shall have one vote, regardless of the number of its representatives. When a head of state leads a delegation to the council, he or she is a representative of his or her state to the Council of the League. The first paragraph of Article 14 of the Pact concerning immunities reads as follows, quote, "The members of the Council of the League, the members of its committees, and such of its officials as shall be designated in internal organization shall enjoy in the exercise of their duties diplomatic privileges and immunities," unquote. In order to specify in greater detail the kinds of privileges and immunities referred to in the Pact and to define clearly the manner of their application, the Council of the League adopted the 1953 Convention. The overall purpose of the 1953 Convention is to facilitate the exercise of the League's function in the territories of member states, while the purpose in according privileges and immunities under Chapter 4 of the Convention is to representatives of member states of the League is to safeguard the independent exercise of their functions in connection with the League. Among other things, the 1953 Convention provides in Article 11 that, and quote, "Representatives of member states to the principal and subsidiary organs of the League of Arab States and to conferences convened by the League shall, while exercising their functions and during the journey to and from the place of meetings, enjoy the following privileges and immunities. A, immunity from personal arrest or detention and from seizure of their personal belongings, personal effects," unquote. Further, Article 14 of the 1953 Convention provides that privileges, quote, "privileges and immunities are accorded to the representatives of member states, not for their personal benefit, but in order to safeguard the independent exercise of their functions in connection with the League. Consequently, member states must waive the immunity of their representatives in all cases where it appears that the immunity would impede the course of justice and if it can be waived without prejudice to the purpose for which the immunity is accorded," unquote. The League regards these provisions as crystal clear. While on Jordanian territory, for purposes of the 28th Arab League Summit, President al-Bashir acted on behalf of a member of the Council of the League. As a representative of Sudan to the Council of the League, he enjoyed immunity from arrest or detention by Jordan, both under Article 14 of the Pact of the League and Article 11 of the 1953 Convention. The Chamber's error is material, given that central arguments of Jordan is that it was under a treaty obligation to accord immunity to President al-Bashir during his visit to Jordan in March 2017. Another question of direct concern to the League in the present case is whether these obligations of Jordan or of any other member state of the League that is a party to the Rome Statute are somehow suspended by obligations under the Rome Statute. In the League's view, they are not. The prosecution contends that Article 27, paragraph 2 of the Rome Statute imposes on states parties such as Jordan an obligation that requires them to violate obligations owed to a non-party state such as Sudan. In our view, underlying the prosecution's argument is an erroneous and misguided approach to the interpretation of Article 27, based on a hypothetical series of so-called vertical and horizontal relationships. We have discussed in our written observations why we view this as erroneous and is not even consistent with the pre-trial chamber's reasoning. The League is of the opinion that Article 27, paragraph 2 of the statute does not strip away the immunity of foreign state officials from criminal jurisdiction at the so-called horizontal level. That is, before the domestic courts of parties to the statute. This is clear from the text of the provision, which refers exclusively to immunity with respect to the court's own jurisdiction. Rather, Article 98 of the Rome Statute, entitled Cooperation with respect to waiver of immunity and consent to surrender, clearly provides that if obligations with respect to immunities are owed by a state party to another state, then such immunities continue to operate in the absence of a waiver. In short, Article 27 is making clear that no immunity exists once the defendant is before this court, but Article 98 is expressly and clearly addressing the situation of how to handle immunities owed by a state party to another state in the context of a request for an arrest and surrender to this court. Paragraph 1 of Article 98 says that this court may not proceed with such a request if it would require the requested state to act inconsistently with its obligations under international law with respect to a foreign state official. That is exactly the position in which Jordan found itself in March 2017 in the context of the League Summit. Paragraph 2 of Article 98 says that the court may not proceed with a request for surrender which would require the requested state to act inconsistently with its obligations under international agreements, pursuant to which the consent of a sending state is required to surrender a person of that state to the court. That is exactly the position in which Jordan found itself in March 2017. It cannot be said that the text of Article 98 allows for impunity, for the text itself contemplates the waiver of such immunity. It cannot be said that Article 98 frustrates the object and purpose of the Rome Statute, for the Article 98 is a part of the Rome Statute, and it was intentionally and purposefully drafted by states to address a particular issue of which they were aware of. It also cannot be said that Article 98 defeats fundamental norms of international law, given that those norms include the avoidance of conflict between states, including armed conflicts, which is one of the reasons why the international law on immunity exists. The prosecution challenges this interpretation of the statute. First, it is said that this interpretation reads Article 27 and 98 as being in opposition to one another. The League considers that these two provisions are distinct and serve different purposes, just as Part 3 and Part 9 of the statute address different matters. Further, the League views these two articles as operating in harmony and not in conflict, as we explained in our written observation. As regards Article 98(2) of the Rome Statute, Pretrial Chamber 2 found that it does not apply to the 1953 Convention because the latter does not refer to a sending state and does not establish or refer to a procedure for seeking and providing consent to surrender. The prosecution further argued in its response to Jordan's appeal that Article 98, paragraph 2 only applies to certain kinds of international agreements, which would not include the 1953 Convention. The League finds such arguments wholly unconvincing. There is no reason to regard the ordinary meaning of the term international agreements in Article 98(2) as limited to status of forces agreements or to any other class of agreements. Another important category of international agreements clearly covered by the provision, for example, are those conferring privileges and immunities on persons connected with international organizations, including state representatives.
Council has 5 minutes.
I'm almost one page.
Before you continue, so that I understand the argument, is it your submission that the Convention on Immunities of the Arab League and perhaps also the Pact provision on immunities, I want to understand, are you saying that they belong where? In 98(1) or 98(2) or both?
This is a typically legal question that I would like to consult upon, and I will come back to Your Honor with an answer tomorrow.
Thank you very much. Please proceed.
To adopt the pre-trial chambers and prosecution excessively narrow interpretation of Article 98(2) is inconsistent with the text and object and purpose. The League wishes to confirm that when a state sends a representative to a meeting of the League, it is clearly acting as a sending state within the meaning of Article 98(2). In sum, the League is of the opinion that the pre-trial chamber erred by finding that Article 98 of the statute does not preserve the treaty-based and customary international law immunity from national criminal jurisdiction of foreign state officials, including heads of state or government, not parties to the statute. It should have concluded that Article 98 does preserve such immunities and that the court is obliged to obtain a waiver of immunity or consent to surrender from the foreign state concerned before making request for arrest and surrender. Even if the appeals chamber considers that Article 98 does not preserve the immunities of officials of states parties to the statute by virtue of Article 27(2), those immunities are without doubt preserved with respect to non-party states, such as Sudan, including immunity for the foreign criminal jurisdiction of a state party to the Rome Statute. Mr. President, honorable members of the Appeals Chamber, based on such errors, it is the League's contention that the first ground of appeal should be granted and thank you for your attention.
Thank you very much, Counsel. And we will now turn to the academic friends of the court, Mr. Courier. One question that occurs in the course of the submission of counsel for Arab League, which you may answer now, sir, if you wish, but later on anyone can also address it, will be this. Regardless of where the correct answer lies on the legal question presented, and regardless of the operation of Article 103 of the UN Charter, if it does apply in the end, it is something of a recommendation as a matter of policy that where President Bashir attends a conference of an international regional organization, perhaps it may be a matter of policy for arrest not to be sought. It is an open question. Anyone can take it in time. And on that note, I will turn the microphone over to, I think Mr. Crass will speak next.
Your Honours, many questions of Group A refer to customary international law. Customary international law indeed provides the appeals chamber with a key for a legally correct decision. What is more, only customary international law provides the chamber with a key for a legally correct decision, which is also in line with the fundamental principle of the equal enforcement of the law. The chamber should therefore not avoid the application of customary international law on grounds of judicial economy. To the contrary, the appeals chamber should find that Jordan would have acted consistent with its obligations under customary international law if it had executed the ICC's request to arrest and surrender President Bashir. In this statement, I wish to explain 3 points on the relevant customary law which are key, as the debate so far has shown. First, already at the entry into force of the ICC statute, the customary law immunity ratione personae of a sitting head of state was subject to an exception for proceedings before certain international criminal courts, including the ICC. Second, at the same moment in time, this international criminal court exception included the arrest and surrender of a sitting head of state by a state party upon the request by the ICC. Not, I should clarify in light of the prosecution's earlier statement on my position, not as a customary obligation to arrest and surrender, but as the right to non-existence, as a right to non-existence of immunity. Let me begin by briefly recalling how the customary international criminal court exception to the immunity ratione personae has come into existence. This happened through the ordinary process of the formation of customary international law based on state practice and opinio juris. Starting with Article 7 of the Charter of the Nuremberg Tribunal, none of the international legal texts which are relevant for the elimination of immunities for crimes under international law contains an exception for sitting heads of states. In his reasons of 5 April 2016, in the case against Ruto and Stang, Judge Eboe Ozui has demonstrated that this is no accident. Instead, as the judge set out in some detail, the possibility of proceedings against such sitting state officials had explicitly been contemplated during the preparation of the Nuremberg and Tokyo trials. It is therefore also no accident that the recognition of the customary International Criminal Court exception by the International Law Commission in 1996 again does not contain an exception for sitting heads of states. It is true that the relevant Article 7 of the 1996 ILC draft is formulated in terms of substantive law, but it is also true that the commentary says explicitly that Article 7 is meant to also cover procedural immunities. This reflects the customary evolution. Remember that Article 7 of the Nuremberg Charter was also formulated in terms of substantive law. And this also did not prevent the Nuremberg Tribunal from famously rejecting procedural immunities. Let me recall, the tribunal stated explicitly, I quote, "He who violates the laws of war cannot obtain immunity while acting in pursuance of the authority of the state." That the two paragraphs of Article 27 of the ICC statute distinguish between substance and procedure is certainly a welcome advance in the clarity of legal drafting. But it is not a novelty regarding the content of customary international law. In its 1996 commentary, the ILC had limited the customary exception to immunity to, I quote, appropriate proceedings. The ILC specified, and I quote again, "Judicial proceedings before an international criminal court would be the quintessential example of appropriate judicial proceedings in which an individual could not invoke any substantive or procedural immunity based on his official position to avoid prosecution and punishment." This is the International Criminal Court exception. The ICJ should then authoritatively confirm precisely this exception in paragraph 61 of its judgment in the 2002 arrest warrants case. In full conformity with the prior customary evolution, neither the ILC nor the ICJ limited the International Criminal Court exception to international criminal courts established by the Security Council. To the contrary, the ICJ explicitly included the ICC in this exception. The international criminal proceedings against Slobodan Milosevic and against Charles Taylor were both instituted against sitting heads of states. I am not aware that states in any significant number would have protested against the institution of these proceedings, and rightly so. The international proceedings against Milosevic and Taylor were applications of an already existing rule of customary international law. Pretrial Chamber 1 of this court confirmed this rule in its Malawi and Chad decisions. And the same finding was subsequently reached by Trial Chamber 5A in the case against Ruto and Sang. That chamber even called the customary international law codified in Article 27 of the ICC statute a, I quote, cardinal principle of modern international criminal law. This cardinal principle includes the arrest and surrender of a sitting head of state at the request of the ICC. This is my second point. It's not a novel theory at all. I am making that point since 2008. Let me explain it. Arresting and surrendering a person at the request of the ICC is something fundamentally different from arresting and surrendering a person in the course of national criminal proceedings. If the ICC issues a legally binding request for arrest and surrender for proceedings before it, the ultimate legal justification for the execution of such arrest and surrender does not lie at the national level of the requested state. It resides at the international level. This is why Pretrial Chamber 1 in the Malawi and Chad decisions correctly stated that state parties, when complying with requests issued by the ICC, act as the court's instrument and do not, on substance, exercise their national criminal jurisdiction. Let me use the late Antonio Cacese's famous picture of the International Criminal Tribunal as a giant without limbs to express this basic legal fact in other terms. A cooperating state party is part of the limbs which enable the ICC to move properly. The cooperation limb of the International Criminal Court exception does therefore not conflict with the principle of sovereign equality. Once again, the state party which executes a request issued by the court does not exercise its sovereign national criminal jurisdiction, but it assists the court in exercising the court's international criminal jurisdiction. It is also often said that immunity ratione personae serves to ensure stable international relations. But that a head of state who is responsible for horrendous crimes against entire civilian populations remains sitting in his or her office does certainly not constitute a stability which current international law is meant to protect. If it were otherwise, no international criminal court might ever proceed against a sitting head of states. Thus, only possible procedural errors and political abuse leading to criminal proceedings against an innocent sitting head of states endanger the stable international relations the immunities ratione personae are meant to protect. But this danger does not provide a justification for immunity ratione personae in case a state party is requested by this court to surrender a sitting head of state. Here again, it makes a fundamental difference whether a state exercises its national criminal jurisdiction over a sitting head of state or whether a state assists the ICC in exercising this court's international criminal jurisdiction. Other than, very unfortunately, many national courts all over the globe, the ICC is shielded against the influence of national politics, and it works on the basis of internationally recognized human rights standards. Let me now explain why Article 98(1) of the ICC statute does not at all contradict the fact that the International Criminal Court exception includes the cooperation level. Reference has been made in that context to the unspecified reference in Article 98(1) to, I quote, obligations under international law with respect to the state or diplomatic immunity of a person or property of a third state. It has been argued that this would indicate or even require the application of the immunity ratione personae of a sitting head of a non-state party, which indeed exists in national criminal proceedings, to the cooperation by a state party with the ICC. This claim, however, is based on a fundamental misunderstanding about the nature and the operation of Article 98(1) of the ICC statute. Article 98(1) does not affirm the inconsistency of any immunity obligation with a cooperation request by the court. It does no more than to acknowledge the possibility of such an inconsistency. And it entrusts the court, I quote from the text, "The court may not, with a procedural task to determine, as the case may arise, whether there is indeed an inconsistency." It has also been said very often that Article 98(1) would become redundant if the immunity ratione personae of sitting heads of non-state parties in national criminal proceedings would not bar this court from requesting their arrest and surrender. But this again completely misses the procedural function of Article 98(1). In fact, Article 98(1) cannot become redundant, whatever the substantive result of its application will be. Please consider carefully the consequences if it were otherwise. Article 98(1) would then have the potential to freeze forever the existence of immunity obstacles to the cooperation with the court. Let me make one final observation on the inclusion of the cooperation level in the International Criminal Court exception to the immunity ratione personae. It has been said that the state practice and opinio juris since the adoption of the ICC statute was insufficient to prove this inclusion. But this is not the issue. In 2002, the issue was not to prove the formation of a new rule of customary international law. Instead, the issue was to delineate between the scope of application of an existing rule, the customary immunity ratione personae in national criminal proceeding, and an existing exception to it, the exception regarding international criminal courts. I have just explained why the inclusion of the cooperation level in the International Criminal Court exception constituted the result of a proper delineation. This is the only nuance It's an important nuance with the prosecution because I'm not suggesting that we are in a situation of a legal void. The reasons set out so far are sufficient to explain why, as from the entry into force of the ICC statute, the International Criminal Court exception included the cooperation level. But I wish to provide the Chamber also with a supporting instance of state practice and opinio juris which most directly relates to the cooperation level. As mentioned, the ICTY in 1999 instituted international criminal proceedings against the sitting head of state of the Federal Republic of Yugoslavia, Slobodan Milosevic. In that context, Judge Hunt decided to order all member states of the United Nations to arrest and surrender Slobodan Milosevic if present on their territory. I am not aware of any significant state protest against Judge Hunt's order. This is particularly instructive as the Federal Republic of Yugoslavia at the material time was not as such a UN member state, and the question of state succession remained unresolved. The cooperation order was thus made in full awareness of the possibility that Milosevic was the sitting head of state of a non-state party of the treaty system in question. This brings me to my third and last point. It is true that subsequent to the adoption of the ICC statute, some states have taken the view that the International Criminal Court exception does not include the cooperation level. We have heard this today again. But it is also true that as of today, this state practice and opinio juris is insufficiently consistent to justify the identification of a change of the customary international criminal law exception so that it would no longer include the cooperation level. The prosecution has just set out this inconsistency. In fact, even the practice and opinio juris of African states is far from consistent on that point. For example, the 16 February 2018 judgment of the Appeals Court of Kenya stated that under customary international law, I repeat, under customary international law, because I understood my distinguished colleague, Mr. Tladi, to state otherwise, it was legitimate for Kenya to disregard President Bashir's immunity and execute the ICC's request for cooperation by arresting him. To summarize, customary international law provides the ICC with a limbs which enable it to move properly in the case against President Bashir and beyond. Customary international law therefore provides the appeals chamber with a legal avenue in order to decide this case in line with the fundamental principle of equal enforcement of international criminal law. Only the customary law avenue fully corresponds with the very idea of international criminal justice without neglecting any possible countervailing considerations of international law. May the appeals chamber, this is my humble submission, therefore proceed through this avenue. Thank you, sir.
Thank you, Professor. Now, you heard my earlier question about the advisability of the policy sort of position. Yes, of course, the law is what it is, but there are times when sensible application of policy can, as a practical matter, avoid some difficulties, perhaps some may say for a good cause. The question then becomes this: in a context in which Mr. Bashir travels to a country for purposes of an international organization summit like Arab League, the African Union, perhaps the European Union, and so on, would it be something to think of as a matter of policy if the OTP could refrain from proceeding for arrest warrant in those circumstances, as opposed to other instances of visit to a state?
Yeah. Thank you for this question, Mr. President. I have, of course, confined my submissions entirely to questions of international law. This is what I understood my mission to be. I'm not ignoring that there might be situations where there is room for policy considerations. I, as a scholar of international law, are probably not the most suitable person to give advice on these issues. But
you are a citizen of the world.
I am.
Beyond being a professor of international
and in this capacity, I would give one humble advice, that to deal with such policy concerns on the, so to speak, political basis on the way, or in a pragmatic manner, but not by recognizing a legal, far-reaching exception to cooperation by immunity law, which, quite to the contrary, takes away all political flexibility.
Thank you very much. Next on the lineup would be Ms. Latanzi, Professor Latanzi.
Alors, je recommence, excusez-moi. Alors, Monsieur le Président, merci de me donner la parole en tant qu'amicus curiae. Honorable juge, permettez-moi une annotation préliminaire. Les opinions que je vais traiter présenter à votre attention sont le résultat d'une réflexion collective de ma part, de la part du professeur Mirko Sossai et le docteur en droit Lice Riccardi, avec l'assistance de mademoiselle Flavia Pacella et Laura Di Francesco. Donc, les réponses aux questions du groupe A. La présente Chambre est confrontée ici à des questions juridiques complexes auxquelles les chambres préliminaires ont fait face de façon pas trop linéaire, surtout en ce qui concerne, mais je dirais même uniquement, en ce qui concerne le fondement de l'exclusion de l'immunité des chefs d'État, même si le résultat a été toujours le même. Ces questions sont aussi très débattues parmi les amici curiae. Mais c'est à la Chambre d'appel, je crois, qu'il incombe la responsabilité de ne pas perdre de vue, parmi ces différentes opinions, la tâche importante que le statut lui confie, celle de ne pas parcelliser les règles applicables, mais de les interpréter de façon coordonnée et contextuelle à la lumière du but et de l'objet qu'elles poursuivent, tels qu'ils apparaissent clairement dans tous les travaux préparatoires et qu'ils sont consacrés dans le préambule, en particulier par la disposition citée dans la question petit a. Parmi ces règles, il y a également les dispositions de la résolution du Conseil de sécurité 1593, qui doit elle aussi, en tant qu'instrument applicable, en l'espèce, recevoir une interprétation coordonnée et contextuelle avec les règles applicables du statut. En suivant un tel critère d'interprétation, qui est d'ailleurs imposé comme fondamental dans la Convention de Vienne, la Chambre ne pourra qu'arriver à la conclusion que l'impunité pour les crimes les plus graves qui touchent à l'ensemble de la communauté internationale ne peut pas cesser et la paix au Darfour ne peut pas être atteinte si les plus hauts responsables, y compris le chef d'État dissident, ne sont pas jugés. Ce sont ces éléments qui ont inspiré toutes les dispositions du statut, ainsi que la résolution du Conseil de sécurité prise sur la base du rapport de la commission Cassese. Et ce sont ces éléments surtout, qui devront illuminer la Chambre dans sa décision. L'article 21.1 du statut a codifié le principe général ius lex specialis derogat generali. Donc la Cour doit appliquer en premier toutes les dispositions du statut, même si elles dérogent à des normes coutumières qui ne soient pas reconnues comme normes de ius cogens, comme c'est le cas justement pour la norme sur l'immunité personnelle des chefs d'État, qui ne touche pas au principe de souveraineté des États, je dirai pourquoi après, et donc n'est pas une norme, si elle est coutumière, n'est en tout cas pas une norme de ius cogens. Cette norme sur l'immunité personnelle des agents d'État, tout en étant importante pour garantir le ius representationis, omnimode, peut donc être dérogée par l'article 27. En deuxième ligne, seulement si nécessaire, et je souligne cela en ce qui concerne quelque chose qui a été tout à l'heure dit par l'agent de la Jordanie, la Cour, si nécessaire, la Cour appliquera les autres normes du droit international, y compris les normes coutumières pertinentes en l'espèce. Au sens de l'article 21.1c, la Cour pourra aussi appliquer les principes généraux du droit, tels que l'abus de droit. Elle sera tenue d'appliquer en tout cas seulement les normes coutumières tenues d'appliquer, des ius cogens, en particulier en conformité avec l'article 21.3, les normes en matière de droits de l'homme. Du fait qu'au sens de l'article 21.3, la Cour est tenue d'appliquer et interpréter le droit conformément aux droits de l'homme, il descend, selon moi, qu'elle doit garantir qu'aucun auteur de graves violations de ces droits, dans des situations sous sa juridiction, ne reste impuni, indépendant de sa qualité officielle, de la qualité officielle de l'individu. Donc, l'article 88.1 sera interprété par la Cour dans le but d'assurer à la justice, indépendant de sa qualité officielle, toute personne sous mandat d'arrêt par la Cour pour crimes d'agression, génocide, crimes de guerre, crimes contre l'humanité. En plus, au sens de l'article 2.3a du Pacte sur le droit civil et politique, les victimes des crimes dans la situation de Darfour ont au moins le droit au remède de l'établissement de la vérité judiciaire. Alors même, comme le dit l'article, que la violation aurait été commise par des personnes agissant dans l'exercice de leurs fonctions officielles. Vu que le statut n'admet pas le procès in absentia, la vérité judiciaire sur les crimes du Darfour ne saurait pas être atteinte sans l'arrestation et la remise de celui qui est accusé d'être le plus haut responsable. Tous les États parties du pacte, y compris le Soudan et la Jordanie, ont donc l'obligation de coopérer avec la Cour en vue également du respect de ce droit fondamental établi par le pacte, reconnu par le pacte. La violation de tels droits mériterait, selon nous, d'être elle aussi constatée par l'Assemblée des États partis et ou par le Conseil de sécurité en vertu de l'applicabilité du pacte au sens de l'article 21.3. Sans aucun doute, les interdictions de commettre les crimes desquels al-Bashir est accusé font l'objet de normes impératives du droit international général, comme la Cour internationale de justice l'a bien affirmé, et dans différentes affaires, et en particulier dans l'affaire activité armée sur le territoire du Congo. Le tribunal pour la ex-Yougoslavie l'a d'ailleurs affirmé par rapport à tous les crimes de droit international sous sa juridiction dans de nombreuses affaires comme Kupreskic, Forunja, Delalic et Krstic. Le caractère du jus cogens de ces interdictions est également reconnu par la jurisprudence interne et de façon unanime par la doctrine. Qu'on voit en particulier pour la jurisprudence interne l'affaire Pinochet devant les tribunaux du Royaume-Uni et l'affaire Bouters devant les tribunaux hollandais. Les dispositions internationales en matière d'immunité relationnée personnes des agents d'État, soient-elles de nature coutumière ou de nature conventionnelle, ne sauraient pas l'emporter sur les normes impératives parce que telle immunité n'est pas l'expression du principe de souveraineté, comme c'est par contre pour les immunités des États en tant que telles. Les immunités personnelles sont en fait seulement l'expression de l'intérêt des États à l'exercice régulier de leurs relations bilatérales et multilatérales, aussi par le biais du jus représentation et omnimodé attribué aux chefs d'État et de gouvernement et au ministère des Affaires étrangères. Il s'agit donc du droit à l'humanité dont est destinataire l'État et non pas l'individu. Le chef d'État en est simplement le bénéficiaire, quand l'État fait valoir son droit, ce qui est bien son propre droit de l'État, ce qui est bien exprimé par l'article 14 de la Convention de la Ligue arabe de 1953, que je cite. Les immunités ne sauraient être accordées aux représentants de l'État membre à leur bénéfice personnel. Il ne s'agit donc même pas d'un privilège auquel l'individu aurait droit, étant moins un droit fondamental comme on l'a ici soutenu. Comme la Cour internationale de justice l'a soutenu dans l'affaire relative au mandat d'arrêt en 2000, au paragraphe 61, une exception à l'immunité personnelle des chefs d'État et des ministres des Affaires étrangères peut donc être établie par des règles contenues dans les statuts des tribunaux internationaux ou hybrides compétents en matière de crimes de droit international. Il s'agit là, à notre avis, de l'application du principe lex specialis derogate generali, c'est-à-dire d'une dérogation conventionnelle à la norme coutumière sur l'immunité. La Cour mentionne trois autres hypothèses d'exception: la renonciation de l'État, l'absence de prévision de l'immunité devant la juridiction d'appartenance, la cessation de l'immunité parce que la fonction cesse. Le fait que l'État puisse renoncer à telle immunité, y compris à celle qui s'attache à la qualité de chef d'État, confirme sa subordination aux règles du jus cogens. Il faut aussi souligner dans ce contexte que dans la pratique étatique et dans la jurisprudence, il n'y a aucune trace d'une distinction des immunités personnelles entre une représentation dans les rapports interétatiques directs ou une représentation des États dans l'activité des organisations internationales. Ce qui était le cas concernant la présence de M. Al-Bashir sur le territoire jordanien. Dans les deux cas, l'immunité peut subir limitation, exception et renonciation, comme d'ailleurs la même convention de la Ligue arabe le confirme. Un établissement à l'article 14, paragraphe 2, que les États membres devraient renoncer à l'immunité de leurs représentants dans les cas où l'immunité apparaîtrait entraver le cours de la justice. ce qui est justement le cas en l'espèce. Une partie de la doctrine affirme que les normes du statut qui prévoient l'exception à l'immunité confirmeraient la norme coutumière qui se serait formée à partir du traité de Versailles ou du statut de Nuremberg. Certains auteurs limitent cette exception aux procédures devant les tribunaux pénaux internationaux, selon la thèse qu'on a à peine entendue du professeur Kress. D'autres étendent l'exception aux procédures relatives aux crimes de droit international devant les juridictions internes. S'il existe une exception de droit coutumier à l'immunité devant les juridictions des tribunaux pénaux internationaux, cette exception ne peut qu'avoir un effet erga omnes, pas dius cogens. En application de cette règle, un chef d'État ne bénéficierait pas d'immunité par rapport à l'exécution par tout autre État des mandats d'arrêt d'un tribunal pénal international. Au contraire, si l'on affirme que l'exception à l'immunité personnelle d'un chef d'État est établie par le statut de la Cour pénale internationale comme d'autres tribunaux, en tant que lex specialis, par rapport à la règle coutumière sur l'humanité, l'exception aura une application subjective limitée, en s'adressant uniquement aux États obligés par le statut. Il est indéniable que, surtout après l'adoption du statut de Rome, une tendance se soit développée dans la pratique étatique et jurisprudentielle qui va dans la direction de la formation d'une règle coutumière sur l'exception ratione materiae à l'immunité personnelle, c'est-à-dire par rapport aux crimes de droit international devant les juridictions internationales et de façon plus prudente devant les juridictions internes nationales. En fait, même sur des fondements différents, l'exception de chef d'État devant les juridictions internationales a été appliquée à l'égard de chefs d'État en fonction. Je ne vais pas répéter ce qu'a déjà dit sur cet aspect le professeur Kress. Et elle a même été cette exception en disant aussi, comme par le président de cette Chambre, qu'elle aurait le caractère de droit coutumier. Elle a été même appliquée dans le cadre de la Cour pénale internationale, en particulier en ce qui concerne un chef, vice-président Ruto du Kenya. Dans ces affaires, différentes affaires, on a fait naturellement référence à la règle statutaire que quelqu'un a considéré des droits coutumiers. La Cour internationale de justice, il faut en tenir compte, n'a évoqué la nature coutumière de cette exception par rapport à des accusations devant les tribunaux pénaux internationaux, ni en négatif ni en positif, a laissé ouverte la question. En tout cas, dans l'hypothèse de l'existence d'une exception de droit coutumier à l'immunité personnelle des chefs d'État à l'égard d'une arrestation demandée par la Cour, une immunité établie par une norme conventionnelle spécifique ne saurait, d'après nous, déroger à la dite exception de droit coutumier, parce que cette exception serait née en fonction de la protection de valeurs fondamentales humanitaires. Ce sont justement ces valeurs qui ont conduit à l'institution de la Cour pénale internationale. Surtout parce que les juridictions nationales laissent très souvent impunis justement les plus hauts responsables. En ce qui concerne la juridiction interne concernant l'immunité personnelle par rapport aux accusations de crimes de droit international devant les juridictions internes, on trouve quelques traces d'affirmation d'une règle coutumière, faisant exception. Par exemple, dans l'affaire implicitement de la cassation française dans Gheddafi, mais de façon très implicite. Cette tendance s'est même manifestée en ce qui concerne l'inviolabilité d'exécution des biens étatiques, qui a été niée par les juges italiens afin de protéger le droit fondamental des victimes de crimes de guerre à un recours effectif et donc leur droit à revendiquer la réparation par l'État responsable. Comme voit la position récente de la Cour constitutionnelle italienne qui a confirmé le fondement constitutionnel de telles exceptions. La Cour internationale de justice n'a pas retenu suffisante la jurisprudence interne reconnaissant l'exception ratione materie devant les juridictions internes. Je considère que la tendance en cours ne se soit encore consolidée, même pas dans les années successives à l'affaire Hierodia. Elle reste encore, cette norme, une norme de droit conventionnel, là où elle est prévue. Mais on ne peut pas quand même méconnaître que les statuts des tribunaux internationaux hybrides contiennent tous une telle exception. Et on a déjà vu que ces tribunaux l'ont même appliqué en affermissant son nature coutumière. Cette tendance a sûrement reçu un élan avec l'institution de la Cour pénale internationale. Donc, une cour à caractère permanent, disposant d'une juridiction géographiquement universelle. J'espère que cette tendance puisse se consolider grâce aux ratifications par tous les États, peut-être, du monde du statut de la Cour. Une décision, permettez-moi de dire à vos honorables juges qu'une décision de la Chambre d'appel qui reconnaîtrait l'immunité personnelle d'Al-Bashir stopperait la tendance en cours, dont le fondement est la protection des mêmes valeurs à la base de l'institution de la Cour pénale internationale. En plus, une telle décision violerait l'article 27 du statut applicable en vertu du renvoi par le Conseil de sécurité, ainsi que la même résolution du Conseil de sécurité, qui exige la coopération pleine du Soudan et sollicite de façon très ferme les autres États, tous les autres États, cette coopération. Elle violerait aussi la Convention contre le génocide par rapport à l'accusation pour ce crime. Et donc, je pense, et je ne m'arrête pas sur cet aspect pour l'économie du temps, je considère que la Convention contre le génocide est aussi applicable par la Cour, par votre Chambre d'appel, en ce qui concerne l'imputation de génocide. Mais rapidement, permettez-moi un aspect que je considère très important et qui concerne l'interprétation de l'article 18.1. Il établit un pouvoir de la Cour. Il ne prévoit pas une obligation, comme on l'a dit aujourd'hui aussi dans cette audience. Pas une obligation de tenir compte de normes qui ne sont même pas implicitement indiquées dans l'article en ce qui concerne la matière de l'immunité. Donc, c'est un pouvoir dont le dominus exclusif est la Cour pénale internationale. Et du contenu de cet article, il n'apparaît pas du tout que l'article 98 autorise les États à opposer à la Cour pénale internationale des normes en matière d'immunité incompatibles avec l'article 27 et applicables dans d'autres contextes comme les juridictions internes, par exemple. Sur cela, et je conclus mon intervention, je crois qu'il faut comprendre qu'il y a malentendu, une confusion dans la lecture, l'interprétation du terme juridiction dont à l'article 27. La juridiction, toute juridiction, que ce soit internationale ou interne, est une juridiction ou de commission ou d'exécution. Et la Cour pénale internationale, en ce qui concerne le mandat d'arrêt et de la demande de remise à la Cour d'un accusé, exerce une juridiction d'exécution. Et donc, ce n'est pas la juridiction interne qui va exercer une telle fonction. C'est toujours la Cour pénale internationale. Qu'est-ce que fait la juridiction interne sur les demandes d'arrêt et de remise d'un accusé? La juridiction interne n'est pas du tout concernée. Et il suffit lire l'article 59 pour comprendre que la juridiction de cognition interne n'est pas du tout concernée par la question de l'immunité. Elle est concernée seulement des droits de l'accusé. Elle doit vérifier si l'accusé a été... Je n'ai pas le temps de citer l'article 59. Je me permets de renvoyer tous à la lecture attentive de cet article pour comprendre que la juridiction interne ne va jamais s'occuper, en prenant en considération un mandat d'arrêt et de remise, de la question des immunités d'un individu. Merci. Honorable juge.
Thank you very much, Ms. Lattanzi. Now, next we go to Mr. Maliveras.
Thank you, Mr. President. Thank you, esteemed members of the Appeals Chamber. I will start with the first question. As regards Article 31 of the Vienna Convention of the Law of Treaties, and given that the application of the Rome Statute has raised issues of importance, which apparently were not envisaged by the drafters, the present appeal may legitimately be determined by interpreting the Rome Statute's relevant provisions in a way ensuring that the impunity of Mr. al-Bashir for the alleged perpetration of the most serious crimes to the international community is put to an end. The Rome Statute is no exception to the maxim that treaties are living instruments, and consequently their content ought to reflect at all times the each time prevailing circumstances. However, since the Rome Statute has not been amended to reflect developments, the most appropriate method to ensure that it does not stagnate but maintains its dynamic nature, is to apply Article 31 of the Vienna Convention in a very broad manner. Turning to question B, regarding seeking guidance from customary international law, as this is an overarching legal notion shaped through many centuries, it arguably applies equally to the first and the second paragraphs of Article 21. While the exact content of customary international law is not settled, but debatable, continuously debatable, one would expect that your court would not only seek guidance from it without any hesitation, but actually develop it so as to close existing gaps in fighting impunity for the most serious crimes to the international community. Turning to question E, that jus cogens norms have a more general application than mere grounds for invalidating unlawful international treaties appears to be by now a well-accepted rule. And following the obiter dictum in the decision of the International Criminal Tribunal for the former Yugoslavia in Prosecutor versus Anto Furijija, it would appear that they do have a direct impact on national law as well. While there is no central global authority to authoritatively determine which norms should be regarded as jus cogens, which as customary international law, etc., while the writings of publicists might be biased and state practice politically influenced, the 1996 Code of Crimes Against Peace and Security of Mankind, adopted by the International Law Commission at its 48th session, should be adequate proof that genocide, extermination, torture, and rape are prohibited as jus cogens. And given jus cogens' direct domestic effect, these international crimes, I will argue, constitute by necessary implication absolutely prohibited acts in Sudan as well. Therefore, no impunity should be granted to Mr. al-Bashir as a matter of domestic Sudanese law. Turning to question F.
Counsel, before you continue to question F, you referred to the decision of Furuntia, Furuntia at the ICTY. Do you have a reference for us? If not, you can hand it off later.
The reference, Your President, is IT 95 17/1 T10 Trial Chamber, the judgment of the 10th of December 1998. And as to the obiter dictum, I was referring specifically to what the court said in paragraphs 153 to paragraph 154 of the said judgment.
Thank you very much.
Now, turning to question F. There is also no central global authority to determine the hierarchy of the rules of international law. But presumably, this is a matter falling within the rights of international courts, including this court. And this because international law courts have to apply the rules of international law. They cannot do otherwise. Therefore, this court should consider that it has the competence to rule specifically on the hierarchy between the most serious crimes and other competent rules of international law. It should do so by listening closely to the views and the aspirations of the international community as a whole, because at the end of the day, it is the international community which is the collective end user of the court services. Regarding questions D and O, according to the first paragraph of Article 27 of the Constitution of the Sudan, this is the interim, so-called interim Constitution of 2005, there exists a Bill of Rights as a covenant between the population of the Sudan and the government. All rights and international human rights instruments ratified by Sudan shall be an integral part of this Bill of Rights. This is stated in paragraph 3 of Article 27. Moreover, the legislation implementing the rights enshrined in the said Bill of Rights, and therefore the rights contained in all ratified international instruments by the Sudan, shall not derogate from them. Paragraph 4 of Article 27. Sudan acceded to the International Covenant on Civil and Political Rights on the 18th of March 1986. The provision in the Bill of Rights corresponding to Article 2, Paragraph 3, Indent A of the International Covenant should be considered to be Article 35 of the Constitution, ensuring the right to litigation. And I quote, the Constitution shall be guaranteed for all persons. No person shall be denied the right to resort to justice. Regarding now the exception of acting in an official capacity, Article 60 of the Constitution of the Sudan contains a limited presidential immunity and impeachment clause. In particular, the President of the Sudan can be charged before the Constitutional Court in case of its gross violation, which cannot but include breach of the Bill of Rights. And Article 61 of the Sudanese Constitution stipulates that any person aggrieved by an act of the President, and specifically it mentions a breach of the Bill of Rights, may contest it before the Constitutional Court. In conclusion, the Constitution of the Sudan does not confer upon Mr. al-Bashir unlimited immunity, and considering that the crimes he is accused of constitute gross constitutional violations, the theoretical until today impeachment before the Constitutional Court should be regarded as an effective remedy in the meaning of Article 2, 3a of the International Covenant on Civil and Political Rights. The above considerations also answer question O. Head of state immunity has posteriority to the responsibility for international crimes amounting to core violations of fundamental human rights. It is clear, even from the Sudanese constitution, the provisions of which Jordan arguably failed to take into proper account, that Mr. al-Bashir may not invoke his official capacity to avoid prosecution at a domestic level, let alone prosecution at an international level by the competent transnational criminal court acting in pursuance of a Chapter 7 resolution. Moving to question N. This question essentially asks if customary international law may legitimize overriding the terms of an international convention. Since customary international law is ever evolving and developing, while a convention can be static, especially if there have been important developments which have not been catered for through its amendment or interpretation or state practice, etc., in theory, it should be able to lead to the disapplication of specific treaty clauses. At the end of the day, it all has to do with providing very convincing argumentation. And in the present case, in this appeal, the invocation of the goal to end the disastrous consequences of impunity, the raison d'etre of your court. And if your court were to answer this question in the positive, but finds that the existing argumentation is inadequate or not well developed, it should not hesitate to augment it and to take it to the next level. If the court's argumentation is convincing, it will be applauded and followed in many a year to come. If it is flawed, it will be ignored. But the real or perceived difficulties arising from the parallel existence of the fluid norms of customary international law and the settled norms of conventional international law have to be addressed by your court. And finally, Mr. President, with your permission, I would like to answer the question which you put orally. Now, your question was on the policy of not requesting the arrest of a head of state attending the meeting of the highest organ of an international organization in which this state participates as a member. Mr. President, I do not think this would be a valid reason for not requesting the arrest unless extremely vital national interests of the state concerned were to be discussed at that very meeting. But this was not the case when President al-Bashir attended the summit of the Council of the Arab League in Jordan last year. As is well known, the Council of the Arab League meets twice every year. Once at the level of head of state and once at the level of foreign ministers. Mr. al-Bashir has not attended many of Council summits in the past, but this didn't mean that the Sudan was not considered to be participating in the meeting because another person did represent the Sudan. So the foreign relations of Sudan were not in any way affected by the non-presence of its presidents. Thank you.
Thank you very much. We will now go to the next speaker on the list, and that will be Mr. Newton.
Shut it off. I rise with great respect for this bench. For the record, the slides to which I allude have been submitted into the record last week. They're not currently showing on slides. I've asked for them to be submitted to parties as well. These are public documents, public records. The three things that we've directed to be transferred already were, one, a map of every single trip taken by President Bashir since the issuance of the first arrest warrant. Two, an annual map, an annual breakdown of those trips by location and by including the cancellations. And then three, the full data set which documents all of these things. I rise with great respect for this court and for the difficult issues that you have taken under your charge. These are indeed some of the most contentious and consequential issues of our day. President Bashir took his first trip abroad within 3 weeks of the first issuance of the first arrest warrant. These issues are far more nuanced than very broad issues of public international law and very broad issues of immunity writ large, or even the intellectual issues about the debates we've been talking about between sovereign immunity and the need to address, I would say the imperative need to address the most serious crimes of concern to the international community. Those are very well settled questions in the abstract. This appeal addresses the very difficult balance in contradistinction to the ICTY jurisprudence and the ICTR jurisprudence and even the Sierra Leone jurisprudence, the very difficult balance of the question between a treaty adopted in contradistinction to pure Chapter 7 authority under those tribunals and this practice. In other words, the focus on the correct interpretation of Article 98 and Article 27 and Article 89.1 is most well taken. To that end, Your Honor, we began to notice very early on a discrepancy between the public reports of travel and the actual documentation of travel. And I just want to say for the record that I very much appreciate this bench recognizing the relevance of this data. We've provided the most comprehensive data set in the entire world on these issues, which of course will be in the record and have been provided to the parties. Of particular note, in the first year after the issuance of the first arrest warrant, the President took 15 trips, 14 of which were for official purposes and one of which was for a religious purpose. We began to be very concerned that the data as being publicly collected and reported did not include many of those trips. I particularly appreciate, because I speak with the voice of pragmatism, I'm not an advocate for either party, I speak on what the data shows. We can't talk about state practice unless we look at the data that shows, well, state practice. We should not talk about the correct interpretation of states to include non-states parties and states parties, and in our data, a large number of signatory states, without also recognizing that these are very difficult issues of the collision between treaty interpretation and the application of the Rome Statute and the application of the Chapter 7 authority of the Security Council. In this case, as is very well known, Resolution 1593 conferred jurisdiction, conferred the situation, but did not expressly address the issue of immunity of a sitting head of state. That's the fundamental problem in this case. So we began to track the data. And even without these slides, Your Honor, I want to take just a second to thank the team that has worked very, very hard on this data. As I said, it's the most comprehensive data set in the world. The data itself shows 173 documented trips, in distinction to 113 reported by the official organs of the state. To date, there have been 27 reports from the OTP to the UN Security Council on these issues. So any argument that says that those reports provide sufficient basis for decision making, in our view, is inadequate because it does not reflect the correct data. The correct data shows 173 trips. The OTP data only shows about 65% of those trips. Both of those categories include cancellations, and within our data set, we've taken great care to document the reasons for cancellation, which I will move into in a minute. As I said, I speak with a voice of pragmatism. So let me read the numbers into the record for the sake of precision. 113 reported trips, including 23 canceled trips. And I will say the analysis of the data shows that the most effective, the most predictable causal factor for the cancellation of trips is indeed, as has been speculated this morning, and we've talked around this issue, but the data shows that the involvement of domestic courts has been, in fact, the single most important predictive factor in deterring trips or causing cancellations. In every case where a domestic court has taken seriously its responsibility to align domestic law and the international duties to arrest, the trips have either been canceled or the larger summit has been called off. The data does not show whether that was because of overarching political factors or whether, in fact, the pending relevance of an arrest warrant was the causal factor. The other thing we've done in the data, which is available to all the parties and it's available online in the mappingbashir.org website, is we've also categorized the purposes of each trip. As I said, within the first year, there were a multitude of trips, particularly including summits and other official discussions, whether on economic issues, other issues. Some were for state events. Inaugurals, for example, the one state event most recently was to the Olympics with other heads of state there. Some were just for meetings, some were for peace events, and some were for personal reasons. I alluded to the religious reason. There was also some physical health reasons, etc. All of this is in the data. Let me summarize. 104 trips were planned to 14 non-state parties, 93 of which were taken, for an overall cancellation rate of 11%. There were 39 trips planned to 9 signatory states, 35 of which were taken for an overall cancellation rate of around 10%. Not surprisingly, the data shows 30 trips were planned to 10 different states' parties, 22 of which were taken for a slightly larger cancellation rate to states' parties of 27%. The cancellation rate to states' parties is approximately double that of the next category, which is signatory states. That's what the data says. We think it's particularly important to recognize that the reasons for this are unclear. We've done a great deal of in-depth analysis on the data. But one conclusion that is clear, and I say this with the most humility possible, the Mapping Bashir data really does seem to suggest that much of the state practice on non-arrest is in direct relation to President al-Bashir's position as the head of state. In the macro question, head of state immunity, and these macro questions, and on this data set, after the issuance of these arrest warrants, the head of state issue was a causal factor and a very key part of the conversation, a very key part of the political conversation. It was also, in some instances, a key part of the reason for cancellation. The head of state issue is a very central part of this case. Nor does our data suggest that that issue is as easily resolved as it might be in theory in the macro. States are having to wrestle with very, very hard questions. Do they maintain these issues? What's the relevance of Article 98.1, which speaks of the duties between states that would require the requested state to act in a way that might be violative of other duties vis-a-vis other states? Article 89.1 of this statute says that states parties, shall proceed with a request for arrest in all circumstances in accordance with the provisions of their domestic law. So the real battles of shaping domestic conformity with the larger duties flowing either from international treaties or from the broader scope of customary international law, of state immunity, this is causing states to really wrestle with these issues. That is true on the data, both for states parties and for non-states parties. The data shows that the Security Council Resolution 1593 in itself is insufficient to automatically assuage the fears of both states parties and non-states parties and signatory parties that these conflicting legal issues can be easily aligned. The data shows that states are wrestling with this. Now, one way of addressing this, one of the slides deals with the number of trips to non-states parties.
Counsel,
Yes,
one minute. Sorry. Do the data that thank you. The data you're talking about, do they tell us anything about whether or not the states, the host states to those visits, actually had their minds pointed to the question of arrest, and whether there's opinion jurists in their own minds about it? That's one question that I have. Or is it just plainly showing us where President Bashir had been and how many times he'd been there? Second question is, when I read your written matter, it seems you were saying that the majority of those visits were to non-states parties, to the ICC, to the Rome Statute, with the exception of perhaps 2 states or so. But correct me if I'm wrong. If it is the case that the majority of the visits had been to non-states parties, would that tell us anything about what they thought the interpretation of Article 98 would mean in the circumstances for purposes of immunity?
Can I answer your questions in the reverse, Your Honor?
Fair, yes, please.
Well, in reverse, the data over trips to non-state parties reflects that there's been very little discussion about the precise substantive legal issues. In fact, where there is public data, either in the form of statements from foreign ministries or in the form of statements at the various reports of the UN Security Council, there's been severe pushback that says we do not accept that this treaty automatically wipes away all sitting head of state immunity for us as a non-state party. In fact, the data shows, based on our analysis, that the most frequent analysis, the preference for non-states parties, has been more of a political nature. I will read you, for example, the statement from the United States on June the 5th, 2002. For our part, the United States has continued to oppose invitations, facilitation, or support for travel. It's always phrased as a policy preference, as a political imperative, and very little data to show that non-states parties or states parties who have allowed trips have been dissuaded by the mere fact that there's a Security Council resolution. They do not get into the details whether they're operating on the basis of Article 98, on the basis of their reciprocal duties, except for after the fact. The first part of your question was on the opinio juris. Thank you. I've been asked to slow down. That's true. I'm sorry, because I'm trying to summarize all of what graphically is on slides, which will be distributed, which causes me to speak a little faster. I apologize. But the number of trips to states parties, you're right, Your Honor, more trips to non-states parties, and in fact more cancellations to states parties, but a significant number of trips to states parties, which in turn begs the question, your question was about opinio juris, what's the binding legal effect, what can we take away from that as a matter of opinio juris? In fact, the majority of cancellations were not due to ICC pressures or politics, or in fact the invocation, it's the minority of cancellations that are due solely to political pressure or allusions to the Security Council Resolution 1593. In fact, the majority of cancellations oftentimes are just happenstance. So the opinio juris is mixed here, except that in the opposite direction, there are very strong statements from a number of members in the Security Council arguing that head of state immunity remains in place. There are also a number of very strong statements from the foreign ministries, predominantly of non-state parties. The real issue in this case, though, concerns the interface between Article 89.1, which says that state parties shall proceed with requests in accordance with their domestic law. It's well known that Article 27 of the Vienna Convention on Law Treaty says that states cannot invoke their domestic procedures to violate their international obligations. And here we see states parties struggling with that, some of which have made statements, the data also shows, almost a lex specialis argument, that there's an overlapping duty to protect international peace and security, which clearly the Security Council has under Chapter 7, and a subordinate regional duty in the form of the African Union also to address regional peace and security. So there are a number of state statements, answering your question, sir, regarding opinio juris, of nation states saying that the local, regional assessment of international peace and security, which shows that canceling trips based on a refusal of immunity has a greater destabilizing effect than the Security Council. We've interpreted that as a lex specialis agreement, which says that, as a very clear matter, the states parties where President al-Bashir has traveled do not automatically concede that either Article 98.1 is irrelevant to the larger duties, or that 89.1 can automatically be used in their domestic law to supersede larger international duties, or even that just by virtue of the fact that 1593 was enacted under Chapter 7, that alone, without an express waiver of immunity on the Security Council, suffices for all these issues. Again, this is a very complicated contradistinction interface of treaty rights of states and mutual treaty rights, and to include, obviously, the United Nations Charter, which is referenced by your subsequent questions about Article 103. The problem here is that the state practice shows not only a continuing pattern of practice, but after 2004, an accelerating pattern of practice. After 2014, President al-Bashir has increased the amount of travel each year since the second arrest warrant, which is relevant to your question about the Genocide Convention. To the extent that the ICC arrest warrant expanded to include genocide, there's very little evidence of states saying, aha, now we have a corollary collateral obligation under the Genocide Convention, which is additive, that might serve as a domestic basis for our otherwise valid concerns with regard to head of state immunity. In fact, the data shows accelerating travel post-2014. And in our data analysis, we give a lot of credit to the court organs. In the early days, pre-2012-ish, the data was very spotty. Since 2014, the court has done a much, much better job of accurately collecting the data. But as I speak, I will tell you that the posted data that we have provided to the parties and the posted data that is now available on the Mapping Bashir website shows 173 trips, as opposed to 113 reported by the prosecutor or the registry. The data clearly shows that head of state immunity is a core concern and has not automatically served in either direction to eliminate travel on these issues. The political solutions lie beyond my submission. I told you I'm not advocating as an advocate. I'm telling you what the data says. And the data says that there is a residual concern among states based on their duties vis-a-vis other states, and that automatically the Security Council resolution has not dissuaded travel. Now, the prosecution raised in its submission the totally valid suggestion that we may very well be conflating the issue before this case with the consequences. In fact, as we read the data, it's exactly the opposite. The established state practice is that President Bashir has traveled in an increasing manner since 2014, both to states parties and to non-states parties and to signatory states. That's state practice. The opinio juris, as you allude to, is mixed. The best we can do, and I have a document that I'm happy to provide, we've collected every single Security Council statement from every single one of the 27 times that the prosecutor has made a report to the Security Council. We have that to the extent that some of those statements do specifically and intentionally reflect opinio juris. Many others do not. They're on more general political grounds. But I'm happy to provide that document to the court. It's a consolidated PDF of all of those 27 reports since the very first one. And as I say, that document backs up the places where there is opinio juris, and in fact deliberate opinio juris, as opposed to general political statements or statements of expediency. And what you see is, honestly, the data's mixed in terms of specific opinio juris. The idea that the Chapter 7 resolution automatically precludes travel because it imports an international obligation that supersedes all horizontal obligations is not reflected in the statements to the Security Council, except for, I would estimate, maybe 25 to 30% of those statements. An equal or greater number of statements specifically push in the opposite direction, that head of state immunity and therefore the right to comply with other pieces of international law as envisioned by Article 98, or as envisioned by the alignment of domestic systems with their international obligations as envisioned by Article 89. That is very prominent in the Security Council debates. The bottom line is the data does not show that this is a simple, easy matter. And I apologize. These slides, they're queued to come up. They have been provided to the parties as well as the full data set.
Thank you. Before you sit, Council, and we will wrap it up at that. Whether you need to speak to it now or later, at the beginning of your submissions, you said that we are in a different situation from ICTY and ICTR would be. I believe that it's probably a question on the list on this, but let me put it to you now, if you can deal with it. I know you speak to something else, Tata, but to the extent you put that opener on the record. Question is this: would the situation in which we are be really different if, hypothetically speaking, the Security Council had, in passing Resolution 1593, had simply established an ad hoc tribunal in the manner of ICTY and ICTR under Chapter 7, but then referred, or rather attached or annexed, as was done in the ICTR Resolution 1994 it was, and also possibly ICTY, which actually annexed the report of the Secretary General, which annexed the statute of the ICTY. What if 1593 had created an ad hoc tribunal and had simply annexed the Rome Statute to it, adapted with necessary variation? Would we be in a different position in that kind of scenario from where we are now? If not, what's the difference? If you can speak to it now, that's fine. If not, you can take it at another time.
I can, Your Honor, but I note for the record that I exceed my mandate, which was to speak directly to the data. I'm happy to answer that question from my perspective if you'd like.
Go on, please.
I definitely think it's different, because if you go back to the Sierra Leone model, the Charles Taylor issue in terms of sitting head of state immunity was resolved by reference to the fact that that body was created by virtue of Chapter 7 authority. Same thing.
Sierra Leone was
sir.
not, actually.
It was a dual agreement, and if you go back to the jurisdictional findings in the Sierra Leone, the Charles Taylor case, it was that Chapter 7 authority that created the ability to overcome sitting head of state immunity. The same thing was true with regard to the issues when immunity came up in the Yugoslavia context. And the important distinction, I think, is in the duty to cooperate. Article 25 of the Charter says that all nation states have the duty to accept and carry out the mandates of the Security Council under Chapter 7, and is specifically tied to Chapter 7. The problem in this context is that states parties in Part 9 have assumed exactly that same duty, but they've assumed it by virtue of the treaty ratification and by virtue of state consent. In this context, had the Security Council done exactly what you proposed, mandated full cooperation rather than urging cooperation of non-states parties, or simply said, addressed very squarely the issue. I mean, part of the problem that you see when you read security, and I'm conscious of the time, I'll be very brief. When you read the Security Council statements, there's this implicit cry of both states and particularly the prosecutor begging the Security Council to address this question, to clarify this issue, to mandate compliance with all the orders of the court. The Security Council has not done that, which leaves the lacuna of how do states, both states parties and non-states parties, reconcile what are really sui generis issues. These are brand new issues for the first time in the field, this interface between broad principles of non-immunity and broad principles of customary international law, which we all subscribe to, but here the fact that compliance is mandated as a treaty duty. Article 98(1) speaks of the duties owed to other states under larger bodies of international law. Article 89 speaks to the duty of all states parties, not non-states parties, but all states parties, to comply with the requests, the orders of the court, in accordance with their domestic law. So to the extent that domestic law procedures around the world, even in states parties, embed deference to other heads of state or deference for other forms of immunity, it's a barrier. States are then caught in an almost impossible quandary. And the Security Council absolutely, in my view, could have cut through all of that with clarity and definition. So far, they've not shown the political will to do that.
Thank you very much. We will adjourn now and return tomorrow. We will start at 9 o'clock for tomorrow's proceedings. The court is adjourned for the day. Thank you very much, everybody.
All rise. Veuillez vous lever.